You're watching News at Prime. Let's bring you this conversation now. The University of Cape Town's Professor Pierre de Vos is in hot water after the National Prosecuting Authority confirmed that a child pornography case against him has been reopened. The decision comes after the lobby group raised concerns over what it says are shortcomings in the initial case that the NPA dropped due to alleged insufficient evidence. Afriforum's private prosecution arm, and this is the entity that has tried to keep this case alive. Let's speak now to its spokesperson, Bateman, who joins us via the virtual platform. Barry, good evening to you, and thank you for your time. Why has Afriforum fought so hard to keep this case alive?
Good evening, Collie. Well, we go back to September 2022 when the criminal complaint was filed by a representative from Afriforum Youth. The matter was supposedly investigated by the police, and within a few months, the case was closed. We obtained the docket by filing a PIA application, and we got the decision from the NPA, and they cited a lack of evidence. Having had a look at the docket, it became evident that there was, in fact, no evidence. And this was because inside the docket, there were just two statements. And I use the word statement quite loosely because the first was the affidavit commissioned and signed by the complainant, which was the Afriforum Youth member. And the other was an unsigned, uncommissioned statement from in this particular matter, the suspect, Mr. Pierre de Vos. It was based on that the NPA took a decision not to prosecute. We say it's entirely irrational. It was premature, and it was inexplicable that the NPA would be able to make a decision based on that evidence. Yeah. And it was in those representations that the NPA agreed with us, by all indications, that the evidence was patently insufficient. Why we want this matter to be properly investigated? Well, it's a very serious offense, and we strongly believe that everybody must be equal before the law, and where investigations must take place, they must be done thoroughly and correctly.
Yeah. Professor de Vos, I think if I remember back to the initial case, he claimed that his account, his Twitter account, which is now X, had been hacked. You clearly do not believe that statement. Tell us why.
Not that we don't believe what he says. It's that the police haven't investigated what he says. He made the claim publicly, but he also makes it in the statement that was unsigned and uncommissioned, and the police accepted that claim on face value. If every person who was accused of a crime would simply offer up a defense and the police would just simply accept it, well, then we wouldn't have many cases going to court. We wouldn't have many investigations being conducted. We say that just on the evidence or the information that Mr. de Vos provided to the police in his case, he opened a separate case claiming that he was hacked. In the evidence that the documentation he provided there, which included some IP addresses and so on, there appears to be sufficient evidence to show that, in fact, his claims of hacking are questionable. We say that absent any proper analysis to interrogate his claims that he was hacked, the decision not to prosecute is simply irrational. So we're not saying that we don't believe him. What we're saying is that there's not enough evidence that has been gathered for the person who makes the decision to prosecute, being the prosecutor, to make that decision.
Yeah. There is this school of thought, Barry Bateman, that says child pornography is not a victimless crime. And so, if we follow that thought process, what, in your view, if indeed Professor de Vos is finally prosecuted and perhaps prosecuted successfully, what do you believe should be the punishment here? What is it that you believe he would have done through his Twitter account?
Well, the offences that have been filed and the police ought to be investigating relate to the Film and Publications Act as well as the Sexual Offences Act. There's also the Cybercrimes Act, and this relates to not just the distribution of child pornography, but also accessing it. So where you're able to demonstrate and somebody has accessed child pornography, remember that's just accessing, not just the distribution of it, the person would find themselves guilty of an offense. we sit here today during the 16 days of activism, and which is gender-based violence, but also violence against vulnerable people in society, and those being children. So society frowns upon this kind of offense. It is a scourge that, in South Africa, we know is a very big problem. So if the courts were to find an individual guilty of such an offences, the punishment could range, I suppose, up to anything from 15 years. But of course, that's up to the courts to decide. But we need to get there first, Holly. That's the important part. Let's conduct the investigation. Let's compile a docket that is thorough and give it to a prosecutor who can make an informed decision on whether or not to proceed with the matter. I just want to add, Holly, that the reason that we believe we find ourselves in a situation where there is an incomplete docket and the prosecutor has not been or has not taken a decision based on a complete docket is we believe that Mr. de Vos has received preferential treatment because of his status, and that this amounts to selective prosecution. So again, we go back to urging the authorities to conduct a proper investigation and make a decision based on all the available evidence.
You touch on a crucial point, which I'm going to end on. You make reference to Pierre de Vos as someone with a particular status, in inverted commas. He is a public figure. We have seen him giving commentary on very complicated legal processes in our country. He is an academic, a very, very respected academic. What is the end goal of the Afriforum here? Is it to use Professor Pierre de Vos as an example of what people should not be doing, and that is to either distribute or, in this case, as you say, access child pornography, because, as we said earlier, it is not a victimless crime?
Well, there's no attempt here to make an example of Mr. de Vos for any conduct he might or might not have done. I think the example to be made here is that everybody must be equal before the law, that irrespective of who you are and what kind of offense you commit, whether it be related to child pornography or corruption or murder or assault, that irrespective of who you are, the police are going to take that complaint and they're going to follow through and conduct a thorough investigation. And it's going to be done without fear, favor, or prejudice. And all the evidence is going to be put into a docket, and the prosecutor who makes the decision is also going to base the decision solely on the facts placed before that person. We strongly believe that it happens far too often in this country, and we see it quite often in senior corruption matters, high-profile corruption matters, where decisions are made not based on the facts, or investigations not followed through because of the status of the individuals. That is the issue that underlies the entire complaint that we're pursuing in this particular matter, Dolly, is that the matter wasn't properly investigated, that on just a cursory inspection by our office, it is evident that there are numerous lines of investigations that were simply not followed up. We're asking why. We're saying it's because of the status of the individual, but we've now at least got confirmation from the National Prosecuting Authority that at the very least our representations were persuasive and that those lines of investigation are now being ordered to be done by the NPA.
Barry Bateman, thank you very much for your time. Afriforum's private prosecution spokesperson. All right.